Hi, we're
Inside this
back.
Michigan courtroom, routine quickly spirals into chaos. 8 pending cases, 1 defendant, and a judge who's clearly running out of patience. But what begins as a simple pre-trial hearing turns into one of the most unusual moments caught on record, a scene that leaves even the judge backing away from the bench. Sinquaz Marie Furlow, a repeat offender with theft, assault, and driving charges stacked against her, walks in with something no courtroom expected that day: her sick child. What happens next forces the entire session to a stop. Would you have handled it differently if you were the
Hi, we're
judge?
back for our afternoon docket. It's 1:59. We expect the prosecutor will be here momentarily. Mr. Truckee is here. His client is here. Ms. Furlow, would you come over here and have a seat, please? The lyric today was, there is a young cowboy who lives on the range. His horse and his cattle are his only companions. Mr. George doesn't know it, but Mr. Truckee does. Mr. Truckee, have
The
you been
legal
in discussion?
tension begins quietly. The judge reviews a mountain of misdemeanor and ordinance violations, from driving without insurance to operating while suspended. Each case on its own might sound minor, but together they paint a troubling picture: a defendant who's been evading accountability for years. Michigan's lower courts often face this dilemma: limited resources, repeat offenders, and endless probation violations. What's different today is the judge's tone: calm, deliberate, and almost weary. He's not just reading charges, he's cataloguing a history. Do you think repeat misdemeanors should ever stack into felonies?
Have you been in discussion with the prosecutor on these matters?
Yes, Your Honor.
All right, some are ordinance and some are state statute. Mr. George is also here on behalf of the ordinance cases. I tried to put these in chronological order.
We have a resolution on Mr. George's file.
All right. Which prosecutor have you been working with?
Ms. Camfield.
All right, very good.
In fact, I was just with her.
I'm sure she'll be here in just a minute. This is the only pretrial we have this afternoon, and it involves 8 separate cases, but we have just one defendant. So our whole lot of time we can spend on your cases. We're on a live feed. I have turned the record on also. guess we can start to just detail everything that's scheduled for today. As I said, some are ordinance cases, some are state statute cases. And they all involve Sinquaz Marie Furlow. That's you?
Yes.
All right. The first case in time is a state statute, 24881. It alleges that on April 16th of 2024, you drove a vehicle without security. You failed to stop at the scene of a property damage accident. You had open intoxicants in a vehicle. You had no valid operator's license. Sometimes it got charged as no ops. Sometimes it got charged as driving suspended, but this is charged as no ops and charged with unlawful use of a license plate. Most serious of those charges is the no insurance, which carries a penalty of up to a year in jail and a fine of not less than $200, not more than $500. That's April of 2024.
By the time 2024 rolls around, Sinquaz's name has appeared in almost every district within the county. Constantine, Centerville, Three Rivers. Charges range from driving uninsured to open intoxicants to stealing liquor and retail fraud. What's striking isn't the severity of the crimes, it's the repetition. Judges often call this chronic misdemeanor behavior, a pattern that signals disregard for rehabilitation. Each missed appearance adds another bench warrant, another delay, another excuse. And through it all, Sinquaz remains unfazed, sitting quietly as her record unfolds like a cautionary timeline of wasted chances. Would you still call this petty crime or chronic
In
defiance?
file 251764, she's charged alleging that on May 2nd of 2025, that she stole $682 worth of stuff from the Walmart store in Three Rivers. That's charged as retail fraud, second degree. Then June 1st of 2025, it's alleged that she ran into Paul's Pantry store in Three Rivers and stole several expensive bottles of liquor. And that is also a retail fraud, second degree, punishable by up to a year in jail and a fine of up to $2,000. And some of these, there's a video, alleged to be a video. There is in that one. There is in the Walmart one. I don't know about the others. So one of these is under Three Rivers ordinance. Everything else is under state statute. Angelique Camfield is here, and she's inherited some of these. They happened before she joined the office. As I indicated, there have been a number of missed hearings and bench warrants and that sort of thing, but I think we finally at least got on track to get everything here. Miss Sinquaz Furlow also had some health issues which caused things to be adjourned. So I set all 8 of her cases for pretrial today. Mr. Truckee has all of them. In fact, we were here on an earlier one and some of the new charges have come out. So I think we've got everything. Ms. Camfield, are you aware of anything else that's pending against the defendant?
I don't believe so, Your Honor. I have 6 of the files and I made a package offer. I did speak with Mr. Truckee earlier today as well as yesterday, and I think it'll be partially accepted. And then a couple matters may be set for trial.
All right. What's the prosecutor's offer on these matters?
Then the calendar flips to 2025, and things escalate fast. 2 domestic violence charges, multiple thefts, and even more retail frauds, including one at Walmart caught on video. This isn't just minor theft. It's a repeat cycle of aggression and impulse. Under Michigan law, domestic violence and retail fraud can trigger probation revocations and longer jail terms, especially when combined. But here's the kicker. Despite dozens of cases, she's still walking free, sitting in court today to face them all at once. The real question now isn't guilt. It's how much leniency is left to give.
I'm getting into my system now, which is giving me fits and starts in the moment.
I'd also have to inquire about file number 7. Ms. Campfield indicates she's got 6.
I thought I had, let me
I
count.
have 8.
Yeah, 1, 2, 3, 4, 5, 6, 7, 8. Only one of them is ordinance.
Oh, okay, well.
I just recited them while I was waiting for you to get here. Maybe I should have waited.
I was on a call. Let me see if I can find it. I don't know. I don't show anything pending in review.
All right, well, let's hear what your offer is, then we'll
Okay.
parse out what cases we have.
All right. So the offer was to plead guilty to 1 count of domestic violence and 25 to 59 DM, dismiss the remaining counts. Plead guilty to retail fraud 2nd degree and 251406, dismiss 25358 and 24911. I would request restitution on all of those, however. Plead guilty to leaving the scene of a property damage accident and open intoxicants and no license. Dismiss improper plate and no security. I'm going to refrain from the recommendation because of the juvenile present in the courtroom.
When the prosecutor finally speaks, the strategy becomes clear: consolidate chaos. Rather than take 8 cases to trial, she offers a plea deal. Plead guilty to select charges and the rest get dismissed. It's called a package plea, a common tactic to close multiple files efficiently. But for Sinquaz, it's more than a shortcut. It's survival. Facing years of potential jail time, she's being handed a way out again. The judge listens quietly, weighing not just the law, but the pattern, rehabilitation, or repetition. If you were the prosecutor, would you cut her that deal?
Yes, I'm not thrilled about that.
Can I say something?
Yes.
I had to bring her, we leave her in the hospital. She got hands, mouth, and feet, so I didn't have to.
Oh, boy.
Yeah, she didn't have a baby.
I don't want her in here.
No, I know. I didn't.
Mr.
Yeah.
George has suffered through hand, mouth, and
Yeah, I've
feet.
never heard of it until she started going to
She's
school.
got it right now?
Yes,
Oh, my gosh.
yes. I had to bring her. She can't go to school. She's in school. That's where she got it from.
Mr. George, what's your offer?
Your Honor, we would offer that if she were to plead to no valid operator's license, we would dismiss the civil infraction.
I'm going to adjourn this.
Then, the entire hearing takes a bizarre turn. The defendant interrupts, explaining why she brought her daughter. The child is infected with hand, foot, and mouth disease, a highly contagious virus. You can hear the room shift. The judge freezes, visibly alarmed. For a moment, the legal tension dissolves into human panic. It's a surreal scene, a courtroom filled with lawyers, a sick toddler in the corner, and a judge realizing the building may now need to be sanitized. It's both absurd and tragic, a symbol of how dysfunction follows Sinquaz everywhere. Would you have halted the session too?
I'm gonna adjourn this. This is highly contagious disease that's very debilitating. The adults that I know that have recently had it had very terrible and serious consequences. She shouldn't be in here.
Yeah.
So as much as I'd like to resolve this today, I'm gonna call the maintenance department and have them come spray this room down. We're gonna reschedule this, and you're not to bring any children with you when you come. You'll have time to discuss the plea offer.
Okay.
Gee whiz. Ross, are you here on October 16th? Looking.
Yeah, yeah, did my mom call you and tell you about that? After I had came to court from Middleton, Officer Britton had followed me while I was walking home to her house.
We can talk about this.
Okay.
Probably don't need to talk about
Oh,
it.
yeah, he was talking about the 16th.
You're not on the 16th. You're here. Are you here on the 9th?
I'll tell you something.
I'm not.
Are you
And I've got a
available?
1:30 with Judge Kane on the 9th.
All right. How are you available on the 16th?
It looks like I could be here 1 or 2.
All right, let's continue this to 2:30 on October 16th. Ms. Furlow.
The judge's professionalism breaks, but not his authority. We're going to adjourn this, he says sharply, calling for the maintenance crew to disinfect the room. You can feel the frustration in his voice. Years of no-shows, health excuses, now an exposed courtroom. His patience has snapped, yet his restraint is textbook judicial balance. Protect public health, protect the record, avoid chaos. He warns her not to bring any child again. The subtext is clear. He's done with her excuses. Would you have kept calm in that moment or lost it completely?
Ms. Furlow, there's a substantial chance that you're going to jail.
Okay.
These are a bunch of cases, thefts, assaults, driving. You've got a bunch of thefts, assault, and driving convictions. You have at least 2 assault convictions, 4 or 5 retail frauds. You never show up. Sometimes it's medical, sometimes it's neglect. And so I don't want you to bring any children with you, and I don't want you to bring any children that have a communicable disease. So we're going to adjourn this matter. I don't wish to even be in the same room with a child that has this infection. So I really would like to finish this today, but I don't want all of us to get hand, foot, and mouth disease. So you're free to go. We're going to pick this up at 2:30, 2 weeks from today.
Okay.
Mr. George,
As
you
the
may be
judge
here
recounts her
anyway.
full record, multiple thefts, assaults, and missed hearings, the room quiets. He's no longer speaking to her as a defendant, but as a warning to anyone watching. The subtext feels almost cinematic. This is what happens when second chances run out. His voice hardens when he says, "You never show up." This isn't just scolding, it's accountability, raw and unscripted. The courtroom has turned into a mirror of responsibility, and Sinquaz Furlow is facing her reflection for the first time. Would you still believe she deserves leniency?
You may be here anyway, but if you're not, I'm not going to require that you be here. For
I already have some scheduled for that.
All right, thank you. We'll be in recess. I really had hoped to finish this today, but I don't want to be in here.
And with that, the hearing ends not with a verdict, but a virus. Literally. The judge clears the courtroom, the staff prepares to disinfect, and another chapter of repeat offences closes.